Thank you so much for joining us today and welcome to the Stanford Alumni in Sustainability Climate Action Forum. We are delighted to have you with us for what I expect will be both an illuminating and, given the stakes, urgent conversation titled Our Constitution, Our Climate, Our Children. Across the United States, young people are increasingly turning to the courts to do something previous generations failed to do: protect their fundamental right to a safe, livable climate. These are not symbolic cases. They are serious constitutional challenges asking whether a government that knowingly fuels climate harm can still be acting in the public interest, especially when the costs are borne by children and generations not yet born. And some of the most important climate cases in UN's history are now unfolding. Today, we are honored to be joined by Philip Gregory, one of the nation's leading constitutional climate litigators from Our Children's Trust, the nonprofit law firm behind many of these landmark youth-led climate lawsuits. Phil will walk us through the legal strategies, constitutional arguments, and importantly, the human stories driving such cases as Juliana versus the United States, Held v. Montana, and Genesis v. the United States EPA. At the heart of these cases is a deceptively simple but profound question. Does the government have a constitutional duty to safeguard the climate system for future generations? Phil brings a rare combination to hit this work and calling: decades of courtroom experience, deep constitutional fluency, and a willingness to challenge long-standing assumptions about power, responsibility, and intergenerational justice. He will share what it means to fight these battles inside the courtroom, why youth plaintiffs have become such powerful messengers, and what these cases could mean not only for U.S. climate law, but for democracy itself. As your co-host today, I am Dana Freeling, a Stanford graduate in anthropology and a member of the Stanford Climate Action Forum Steering Committee. I'm joining you from my home in Finland, proof that climate concern, much like atmospheric carbon, knows no borders. My career spans decades in sustainability and development, and I currently lead a nonprofit providing sustainable education solutions for girls and youth in Tanzania. Phil has served since 2010 as of Counsel on a pro bono basis with Our Children's Trust, while maintaining his litigation practice with the Gregory Law Group in California. His work spans complex property and environmental cases, including title to real property on the California coast and decades-long groundwater contamination, while his other pro bono trial work addressed flooding during Hurricane Katrina, preserving old-growth redwoods in Richardson Grove, and saving coho salmon in the Smith River. In short, he has spent a career standing between irreplaceable nature and irreversible harm. Before I turn the floor over to Phil, a quick note on participation. We warmly invite you to submit your questions throughout the talk using the Q&A box on your screen. We'll reserve time later in the program to bring your questions into the conversation. If we cannot get to all the questions in the time allotted, please feel free to email Phil directly with your inquiries. We will drop that address in the chat. So, without further ado, it is my great pleasure to welcome Phil Gregory. Phil, thank you so much for being with us today and for the work you do on behalf of our Constitution, our climate, and our children.
Well, thanks very much, Dana, and thanks, Stanford, and all of you attending for being prepared for what I hope will be a fascinating talk. I'm going to hit screen share here, and as we all know, hopefully that works just fine. So our Children's Trust, let's first talk about what that is. It's based in Eugene, Oregon, and it's a nonprofit law firm where we represent youth to enforce their right to a livable climate in courts around the world. We support now more than 300 young plaintiffs in landmark litigation, essentially to move forward with the first cases to recognize a child's right to a climate system capable of sustaining human life. As Dana said, we've been working these cases since 2010, and generally our themes are we have a science-powered, evidence-based case where we represent youth, and we don't charge the youth. It's all done to them on a pro bono basis. And we bring these actions in the courts because, as you'll see, we believe that the court system is the best way for the voices of youth to be heard. And why do we represent youth? Well, the lives of 2 billion children are currently threatened by climate change. As Lisa Patel from Stanford Pediatrics said, the climate crisis is the single biggest driver of health for every child born today. Another interesting statistic is that 85% of adolescents and young adults in the United States are at least moderately worried about climate change and its impacts. Now, when we started with these cases, we were concerned about what legal precedents existed for something as vast as climate change. And the first thing we fashioned on is segregation. And so we spent a lot of time studying those cases because climate crisis, like segregation, is a systemic problem. We're not going to solve the climate crisis by shutting down one power plant or saving one polar bear. So we had to look at things like segregation, where you just can't integrate one school or one bus or one lunch counter. So we're guided by Brown. Here's the plaintiffs in the Brown cases. And we also looked at other US litigation with broad systemic judicial remedies, because that's what we were looking for, broad systemic judicial remedies. And we looked at the things like the Pacific Northwest Salmon Treaty, public housing segregation in Chicago in the Gautreaux versus Hill cases, and California prison litigation, where there was a systemic overcrowding issue in prisons. And with that in mind, we filed Juliana versus United States. Here are the 21 Juliana plaintiffs. They're posing here, interestingly, for a Vogue photo shoot in Central Park, New York. And the Juliana case was filed in August 2015 as a Fifth Amendment of the United States Constitution, asserting rights to life, liberty, and personal security, as well as the appropriate use of public trust resources, or better way, the fact that the federal government was damaging our air, our water, our ocean, and our shorelines. And we relied on the fact that there had been years, many decades, in fact, where the federal government had known about the problem. If you go back, for example, to the LBJ administration, you have the report Restoring the Quality of Our Environment, which stated in part that by the year 2000, the increase in atmospheric CO2 may be sufficient to produce measurable and perhaps marked changes in the climate. And then you have the Nixon administration, where you have a memo from then advisor Daniel Patrick Moynihan to John Ehrlichman, which essentially asserted that as a result of climate change, that the level of the sea will increase by 10 feet. Goodbye, New York. Goodbye, Washington, D.C. And if you're familiar with the chart, the Keeling curve, you can see here that back in 65 parts per million were at 320. Parts per million in 69 were 325. Now they're over 425, way over what it at a maximum should be, which is 350 parts per million. After we filed our case, the Department of Justice during the Obama administration filed a motion to dismiss our case. And we filed it in Eugene, and the United States District Court judge there, Ann Aiken, denied the motions to dismiss, saying that she had no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. She went on to write that where a complaint alleges governmental action is affirmatively and substantially damaging the climate system in the way to cause death, shorten lifespans, result in widespread damage to property, dramatically alter the ecosystem, it states a claim for a due process violation. So we proceeded forward in the Juliana case through many hurdles. And I'm just giving you a quick box chart. I'm not going to go into any of these boxes except to show you that our case moved forward in a very complicated timeline between the district court in Eugene, the Ninth Circuit Court of Appeals in San Francisco, and the United States Supreme Court. And twice in 2018, the United States Supreme Court refused to stay the case, refused a motion on the shadow docket brought by the then Trump Department of Justice to stay Juliana. And it was the case moved forward until it went to the Ninth Circuit Court of Appeals, where in a January 2020 decision, 2 of the 3 judges determined that the case could not go forward. And I want you to pay attention about what they said about why the case could not go forward. Because the opinion, and here's the citation if you want to look it up, it's called In Re United States. It's a January 2020 opinion. And the opinion starts by saying that we had put forward a substantial evidentiary record that the federal government has long promoted fossil fuel use, despite knowing that it can cause catastrophic climate change, and that the failure to change existing policy may hasten an environmental apocalypse. So what we have here is the federal government's known, and the federal government not only knows it's causing the problem, but that the failure to change may hasten an environmental apocalypse, and that the problem is approaching a point of no return for these children, jeopardizing critical food and water supplies, for example. But what does the majority say? The majority says, remember, we're talking about children who filed this case. The majority says that the judiciary, the Article 3 branch, the third branch of government, can do nothing about it, cannot redress these injuries, cannot adjudicate these policies that are causing these harms. Instead, these children must be present their case to the political branches of the government or to the electorate at large through the ballot box. So the children, the only way these children can get relief, according to this majority opinion, is for the children to go to the ballot box. Well, we know that is completely unrealistic. And the dissent written by a district court judge in Southern California took them to task. Fundamental rights, she wrote, may not be submitted to vote. They depend on the outcome of no elections. They need to be, fundamental rights need to be beyond the reach of majorities and officials. The dissents went on to say that seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation. And the dissent said, we shouldn't allow them to do that. The majority said, we can't stop them. And so this makes the Juliana case a fascinating decision on the judiciary determining that it doesn't have the power to address the issue of climate change. And if you want to know more about Juliana, there's a wonderful movie available on Netflix. It's called Youth v. Gov, Youth versus Government, Youth v. Gov. It's on Netflix, won numerous awards, and it's all about the Juliana case. We've also filed other cases. The Genesis versus the US EPA case concerns the discount rate that the EPA uses to address cost-benefit analyses in projects and the like. And that case is set for oral argument in the Ninth Circuit tomorrow at 10 a.m. And here we have pictures of some of the Genesis plaintiffs. And then we have another case, Lighthizer versus Trump, that was filed in Missoula, Montana on May 29 by 22 youth from across the country, challenging the Trump administration's unleashing of fossil fuels through various executive orders. The youth plaintiffs in that case are between the ages of 7 and 25. They're from across the nation: Montana, Oregon, Hawaii, California, and Florida. And they have testified and submitted declarations, and the complaint asserts that they have been harmed by wildfire and hurricane evacuations, rising sea levels, climate-related mental health trauma, and the loss of access to government climate data, because as we all know, the current administration is shutting down government climate data. The executive orders we challenged in the Lighthizer case are three listed here for, in essence, unleashing American energy. And these orders use the federal emergency powers to unleash fossil fuels and reinvigorate coal. Now, by the way, coal is all exported that is being saved here. It's not being used, it's being exported away from the United States. And so we've brought the Lighthizer case for constitutional violations. These violations include violations of the Fifth Amendment right to life and liberty by blocking wind, solar, and electric vehicles, unleashing fossil fuels, and dismantling, as I said earlier, the climate science. We also brought a claim for what's called ultra vires action. In other words, the essentially exceeding their authority, the executive overreach, by canceling the National Climate Assessment and dismantling NOAA, NASA, and other science mandated by Congress. And finally, we've worked off the theory of what's called state-created danger, which we could do a whole separate lecture on, but in essence, its state-created danger claim is brought under the Fifth Amendment of the United States Constitution, where the government is knowingly creating and escalating danger and is deliberately indifferent to the danger. So what's at stake in the Lighthizer case is to block implementation of these executive orders, declaring them unconstitutional, and in essence, issuing an injunction to state that the federal agencies will not use these executive orders as the basis going forward for any actions or decisions. When we brought this case in Missoula, Montana, we had a lengthy hearing before Judge Dana Christensen, federal district court judge. And in October, Judge Christensen found that the plaintiff suffered significant injuries and in fact, and determined that the injuries are and will be directly caused by the three challenged orders, that we had presented overwhelming evidence that implementation of these executive orders will increase CO2 concentration and exacerbating the harms. But the court decided that it did not have the judicial power to redress these constitutional injuries caused by the executive orders, relying on the Juliana majority decision, saying we federal courts don't have the power, if you remember. And this judge in Montana said, I believe I'm bound by the Juliana decision. And so my authority, my judicial power is curtailed. And so I cannot redress these injuries, even though I've found the injuries exist, and even though the government is causing the injuries and that they arise to constitutional proportions. So as a result, we filed a notice of appeal. And in April, on April 13, in Portland, Oregon, we'll have oral argument on the appeal. And we hope for an expedited decision, because we are certain that such relief is well within the power of a federal court to award. And again, if you're interested, you can go. I know it's pretty late in the time frame. There's the hearing tomorrow at 10 a.m. in San Francisco in the Ninth Circuit Court of Appeals, or here the hearing on April 13 at the Ninth Circuit in Portland, Oregon. So those are the federal cases. We've also been bringing cases in various states. And I'm sure you're all generally aware that in state constitutions, they have various types of protections of their natural resources, whether it's a right to a healthy environment or right to water, food, or other rights that they have. So the states do have state constitutional protection. So as a result, we've brought cases throughout the nation. Some are active, for example, Utah, Alaska, Hawaii, Florida, Wisconsin. We have active cases now, and we're working to develop cases in other states. But I'd like to talk to you about a couple state cases. The first is Held versus Montana, where I really think we really did, and I'm patting myself on the back here, a wonderful job here, because a decade ago, the idea of youth suing governments for promoting fossil fuel emissions, that seemed naive to many, particularly many in the legal community. They would ask questions like, well, how are you going to prove that climate change was harming or would harm youth? How are we going to show that forcing a state, just one state, to curb greenhouse gas pollution would alleviate harm from climate change? And so the government sanctions fossil fuel projects. How does that abridge constitutional rights? And the notion that youth might ever win such cases seemed like a pipe dream, but especially it would have been viewed as a pipe dream to win case in Montana. In Held, here's where the plaintiffs lived in Montana, and this kind of tracks, if you're familiar with Montana, where the population is throughout the state. Montana's 1972 Constitution includes the right to a clean and healthful environment, the right to individual dignity and equal protection, and the right that those under 18 enjoy all the same fundamental rights as adults. The protection and improvement of the environment provision is especially enlightening. It states the state and each person shall maintain and improve a clean and healthful environment in Montana for present and future generations. And this was the key Montana constitutional provision that we relied on to challenge Montana's fossil fuel energy system, where there's coal mines, extraction, pipelines, and coal and gas power plants. In Montana, they passed what we called the MEPA, Montana Environmental Protection Act limitation. So they amended the Montana Environmental Protection Act, or MEPA, to state that when state agencies conduct environmental reviews, the reviews may not include an evaluation of greenhouse gas emissions and the corresponding impacts to the climate. So the state couldn't consider greenhouse gas emissions, and no state agency could. So by way of example, you have this huge coal mine in Montana, the Rosebud coal mine, and when they sought to expand the Rosebud coal mine, the Montana Environmental Protection Agency said, we can't evaluate actual or potential impacts of fossil fuel emissions because the MEPA limitation prevents us from doing that. So climate change analysis has been excluded from this analysis. So that's that's the statute we challenged in the Held case. And the Held was the first constitutional climate trial. It was in June of 2023 in Helena, Montana, before Judge Kathy Seeley. You can see the many of the youth plaintiffs here, and the courthouse is in the background. Each of the plaintiffs testified, and we may allude to it later, but I just want to have you all think, what it must be like for these youths, some of them 12, 14 years old, to get up on a witness stand in a court of law to testify about how their government is damaging them, and to be cross-examined by attorneys from the State Department of Justice. We also had amazing experts in areas like climate science. We had Mark Jacobson in his photo in the lower right from Stanford on the importance of solar, wind, and water to removing fossil fuel energy. But I want to focus, just because we don't have much time on this, on the testimony of one expert, Pete Erickson. Pete, first, he does fossil fuel accounting. And what he did is to categorize fossil fuel activities in Montana in essence, 3 buckets. One is fossil fuels that are consumed in Montana, fossil fuels extracted in Montana, and fossil fuels transported through or refined in Montana, and came out with 166 million tons of CO2. And what does that mean? Well, I'm going to show you here. This is a graph that Pete used at trial to show what Montana has done with fossil fuels since the Montana Constitution was ratified in 1972. And you can see that based on his accounting, the total cumulative emissions that Montana was responsible for was 3.7 billion metric tons of CO2. But the chart that I think really was significant to Judge Seeley was when Pete said, okay, let's look at not just what Montana's done, but what does the future hold? And if we go, you can see in the 6 coal mines on the left side of my screen, they've extracted 34 million short tons from there. But what are left by way of reserves if nothing is done now? And you see is 707 million short tons. Same reserves for oil, 298 million barrels, or gas, 613 billion cubic feet. So the point is, if the court didn't account for greenhouse gas emissions under the MIPA limitation, then these additional fossil fuels would be extracted and result in emissions. So on August 14, 2023, Judge Seeley issued her findings of fact and conclusions of law, declaring the MIPA limitation unconstitutional and enjoining it, so that, in other words, that the agencies had to consider fossil fuel emissions. One commentator, Michael Gerard, the director of Columbia's Sabin Center for Climate Change Law, said, "I think this is the strongest decision on climate change ever issued by any court." That case then went to the Montana Supreme Court that affirmed the district court in December of 2024. Two key rulings are the Supreme Court found a right to a clean and healthful environment under the Montana Constitution includes the right to a stable climate system that sustains human lives and liberties, and that the plaintiffs had challenged to standing to challenge the constitutionality of laws that infringe upon their inalienable right. If you hear often that, well, what happens in Montana doesn't really matter, it's a spit in the ocean. And the Supreme Court rejected that defense, saying that it doesn't matter, that if it's a problem here and it's a problem in the rest of the world, then we should not do anything about it. It used the term, if everyone else jumped off a bridge, would you do it too? So the court said global greenhouse gas emissions do not insulate the state from its affirmative constitutional duties, and the state does not have a free pass to pollute. So if you want to know more, please go to our Children's Trust website. You can learn all about the held case, the videos of the youth and experts testifying, and see the various documents filed in the case. The next state case I want to talk about is Navahini versus Hawaii Department of Transportation. That case was filed in June of 2022 by 13 children, Hawaii youth, claiming the Hawaii Department of Transportation, or HDOT, prioritized fossil fuels over other forms of transportation. In June 2024, right on the eve of trial, the state settled with the youth. And again, Michael Gerard said this is an extraordinary and unprecedented victory for the youth plaintiffs. The key components of the settlement are the state affirmed the right to a stable climate, affirmed the best science to protect children's rights, include the target of 350 parts per million by the end of the century, and the state agreed to take all actions necessary to achieve zero emissions no later than 2045. What makes a settlement special is the terms. There's developing a model for transportation decarbonization. The court will continue to supervise through 2045. The court made specific findings that achieving zero emissions in transportation is fair in the best interests of children. And it shows all three branches, the legislature, the executive, and the courts working together with youth. And here is the settlement. In the middle there, up above, is the governor. He's with the various youth plaintiffs, along with attorneys, and it was a very important political moment in Hawaii announcing this settlement, particularly because it established a Hawaii Youth Transportation Council, where it gives the youth in Hawaii an opportunity to lead in getting involved in the transportation decisions made by HDOT going forward. Our Children's Trust, we don't just file cases in federal court and in the state courts here, we file them throughout the world. For example, we filed a case LaRose versus His Majesty the King in Canada. And that case is heading for a climate trial starting in October of this year in Vancouver, British Columbia. And we've also brought a petition to the Inter-American Commission on Human Rights. And in essence, what we did here is we took the Juliana plaintiffs and the evidence in Juliana, and based on that, filed a petition with the Inter-American Commission on Human Rights, accusing the federal government of violating international law through its perpetuation of a fossil fuel-based energy system, and requested an investigation. So the first request in our petition is that the Inter-American Commission on Human Rights investigate the United States on this issue. And we base the petition on a pair of historic advisory opinions issued in July of last year by the Inter-American Court on Human Rights and the International Court of Justice, as well as the climate opinion from the International Tribunal on the Law of the Sea in 2024, recognizing climate change as an existential threat to humanity and ecosystems. And these opinions generally state that countries have legal obligations under international law to address climate change in accordance with climate science. And the Inter-American Court opinion declared that there's a right to a healthy climate, and that governments that fail to regulate emissions from private actors and continue to promote fossil fuels could be committing internationally wrongful acts. Our petition is the first legal action seeking to apply these opinions to hold accountable a major emitting state, the federal government. And so what we're hoping is that the court will find the United States is violating the American Declaration on the Rights and Duties of Man, because the United States, as a member of the Organization of American States, or OAS, is bound by that declaration. We've also just, along with the nonprofit Public Justice, filed a petition on behalf of youth plaintiffs from across the country against the EPA for gutting the endangerment finding, the finding that greenhouse gases endanger Americans' health. I think we all know that getting rid of the endangerment finding will stop any government action to curb greenhouse gas emissions. It will hamper federal efforts to preserve and enforce the Clean Air Act, and it will wipe away vehicle emission standards. So what are the implications of all these actions, federal, state, international? Well, what we believe is that the rulings to date, particularly those of Judge Seeley and the Montana Supreme Court and held, the rulings in Navahini and other states, they not only spell out the environmental harms and the effects of climate change on the physical and well-being, mental well-being of youth, but they give a way for courts going forward to reach similar decisions, either after trial or on the basis of a settlement. Again, we all know that lawsuits are not the best way to make policy. In an ideal world, elected officials would be working to cut emissions and prevent climate disasters, but that's not happening. So courts are probably the only vehicle for these youth and future generations to essentially get their voices heard without being vulnerable to industry influence. So that's why we continue to pursue these actions in the courts. Because the role of our courts are to be strong and independent. That's the cornerstone of our liberties, as Judge Aiken wrote in November 2016. The judiciary must not shrink from its role as a co-equal branch of government. And we've talked about why our children's trust and our youth do this. Why do I do this? Well, here on my shoulders is my granddaughter, Alice, and we're here with Kelsey Juliana, the named plaintiff in Juliana versus United States. And at some point in her life now, Alice has grown up. Alice and her brothers, Lincoln and John Jr., they're going to look at me and they're going to say, Papa, what did you do during the climate wars? What did you do to save our natural resources? And I want to be able to look them in the eye and say, I did everything I possibly could to help your future, to preserve this beauty that I grew up with, we all grew up with, and to make sure you're safe and protected. And so with that, I wanted to thank you all very much for hearing me. Again, the contact information for our Children's Trust is here. I'm happy, as Dana said, to entertain emails if we don't get to your questions, or you think of questions right after we sign off this talk. Please email me, follow our Children's Trust on social media. Make yourself a bowl of popcorn and watch Youth versus Gov, and hopefully you'll help us in our effort to preserve our future, and as well as the future for our children, our grandchildren, and generations to come. Thank you.
Thank you so much, Phil. What an extraordinary, detailed, inspiring presentation. True to the Stanford tradition, we have lots of people who have lodged questions for you. I don't know if we have time to get to all of them, but
I think we lost Dana. So I'm going to anticipate a question because I can't see the questions, and I apologize, but a typical question I get asked is, how does an individual become a youth plaintiff? What's involved there? And what happens is we are talking typically to people inside a state. Let's pick Wisconsin or Pennsylvania. And we say to various nonprofits, we're thinking of pursuing a case. Will you work with us? And we then talk to local climate scientists, we talk to local attorneys and the like, and the word gets out. And then we are approached by what I'm going to call youth in the state, through youth climate organizations, through their teachers, through their parents' involvement in nonprofits. And it's extremely important. We then sit down and explain to these youth what's involved. Because again, I don't know what you were doing when you were 14, 16 years old. I was not suing my government. I was not sitting down and writing out how I've been harmed by wildfire smoke, by the trauma of climate change. I was not doing anything along those lines. And these youth take on a huge responsibility. They shoulder a lot of what their peers view as the need to really advocate for youth generally. And so it becomes a very important mission for them. They testify in court, they testify in depositions, they are involved in media interviews. It's an incredible effort by these youth to bring these cases. They get no money for doing any of this. It's only their time, their hearts, and their courage that guide them. And Dana, I took that on. while you inadvertently
Yes,
dropped off.
unfortunately, I was disconnected. Technology, gotta love it. But I'm back. I'm so sorry. So you noticed the first question was, what are our what is the process of becoming a plaintiff?
And I want to just build on that for just a little bit. One of the reasons, an important reason why we have youth as plaintiffs is youth generally need hope that something is being done. And so these youth, by testifying, by getting involved in rallies, etc., by seeing the courts enter decisions, they get hope. But also, we all know the climate crisis is not going to be boom, instantaneous happening right now. It's going to happen over time, and that we can act, we can do something. However, we need to act quickly, otherwise, the harms will worsen over time. And so the science, the medical professionals, and the like testify that the greatest effect is on youth, particularly, and this is the third point, physical, mental health issues that youth experience because their bodies, their brains are much more vulnerable at this stage in their life. And so the impacts of wildfire smoke, if they have asthma, etc., it's going to be much more devastating to them later on. So they have the injuries that are necessary for us to have what's called standing to proceed with the case in federal court.
We have another questioner that asks, can seniors, can other people, it's not just youth, it's also people, of course, who have adverse medical conditions, who are vulnerable, all types of people are vulnerable. Is there a forum for other groups?
That's absolutely true. And so one of the issues that's dramatically improved over time is the concept of what's called attribution science. So you have a hurricane in the Florida Caribbean region. How do you attribute some amount of intensity of that hurricane to fossil fuel emissions? Well, that science has dramatically improved. So now it perhaps would be easier for an adult to establish that the wildfires that are occurring in a region, a certain amount is attributed to fossil fuel emissions and causing the intensity of the wildfire, etc. It's so adults theoretically have claims. There haven't been groups bringing those claims. I think that youth, candidly, are better plaintiffs because adults, their lifespan being shorter, the intensity of the injuries may not get worse. Let's just say the more of a geezer like I am, you are, and so it's youth that really have the clearest forms of injuries and the need for the courts to step in, because the process of resolving some of these issues takes years. In the Juliana case, it was like a decade. Like plaintiffs who were, I think Levi, our youngest plaintiff in Juliana, I think he was 8. He's 18, 19 now. And the point being, it takes a long time for these cases to proceed.
Sure. Sushim Gupta asks, as someone with no background in this space who's very interested in contributing, what can they do?
So, again, I don't know what walk of life you're in, but we at our Children's Trust, for example, we have a volunteer tab. So some people are lawyers or paralegals or somehow connected with the legal profession, and they can help us by writing briefs, amicus briefs, and the like, or help get cases ready for trial, organizing and the like. If you're in other areas, we need scientists. We need people to help us work on the science issues. We need people to help us at the simple things of rallies or get the words out. We need people to sign on to briefs. There's a number of areas where people can help in these cases. Again, my email address is hopefully in the chat, and if it's not, it will be. Email me. If you want to do something, give me a little bit of background on yourself. I will pass that on to our Children's Trust, because they're more than happy to add you to our volunteer network. Because another thing I want to say is, people at, let's call it my age, when we're out front of the courtroom and we're cheering the kids on, in Montana, for example, the adults lined the walkway for well over 100 yards, cheering the youth as they walked into court every morning. I want to tell you, it was dramatic. It really, really gave the kids a additional boost to their courage, particularly those who were going to testify that day, that the adults were standing with them.
Empowering and inspiring, certainly. Chris Kobe, thanks you for the excellent and informative presentation, but would also like to know if they can facilitate possible policy collaboration between the TCT and the League of Women Voters of Oregon on these issues before the Oregon legislature. So I guess coordinating with the legislative branch, is that something that you as an organization oversee or can facilitate?
We do not do much in-state lobbying. We don't. But I certainly can put people in touch with those groups who do. But we're primarily involved in the courts rather than with the legislature. But there's other excellent organizations, like you said, League of Women Voters, that do that type of work in Oregon.
I guess every little bit helps. And another topic, Meredith Wheeler in France asked, given the threats now to immigrants and people of color in the United States under the current administration with ICE and border control, are you finding children of immigrants who were your plaintiffs who actually want to withdraw now? Are they at risk?
We haven't had any youth want to withdraw because of that. However, there's a reluctance of anybody, I don't care what age you are, to take on the Trump administration in court. So imagine you're a parent or a grandparent, and your child or grandchild is thinking of being a named plaintiff suing this administration that is doing nothing but revenge tactics on various people, law firms and the like, who have taken on them in the past or are taking them on now. And you really have to sit down with the youth and explain the potential implications. And these are implications when we started bringing these cases under the Obama administration, under the first Trump administration, or under the Biden administration, really were, while they were issues you'd bring up, remember, you're suing the federal government, or you're suing the state government of whatever, Florida, that these were significant, but the retribution that not only from the administration, but from, I'm going to call it on social media, that these youth can experience is significant. And that adds to the need for them to be courageous, but it also adds to our need to be vigilant to help them. For example, we have counseling for our plaintiffs through trauma-informed care professionals. We really try to recognize what a youth plaintiff is going through, both at the front end in deciding whether or not to join the case, and as we hit various milestones in the case, such as the youth getting ready to testify in a deposition or at trial, or to attend a hearing where government lawyers are going to attack them and their case. So we really try to address that issue. But when you're dealing with someone who's 14, 15, 16, even 18, 19, 20, it's tough for them to understand the long-term implications of what they're going through. And we do our best to try to work with them on that.
We're getting towards the top of the hour. I would like to still ask you a couple of more questions that are waiting in the queue. For those of you who can't stay with us, please do contact Phil if you've got more questions. But we have an interesting, obviously, this gentleman has some experience. Richard Hyman has asked that the judicial feedback seems to be stating that there isn't sufficient law to allow many of these cases to proceed. Organization ALEC has been busy crafting model legislation for state and federal legislatures to use to put in place law that prevents regulation associated with climate change. He provides an example of this model legislation, and he asks, is model legislation something this group might consider putting together? For example, the EPA's reversal of the greenhouse gas endangerment finding might make the case that the Clean Energy Act regulates primary pollutants, et cetera, et cetera. The courts may land on either side. What do you think?
Well, I think it's 5 states have what are called green amendments to their constitution. Montana, back in 1972, when it ratified a new constitution, in large part to address the pollution that was occurring because of the various energy and refinery operations in Montana, put in that clean and healthy environment, and the language is incredibly strong, maintain and improve for present and future generations. Incredibly strong language. Hawaii has similar language, Pennsylvania. Where I'm going with this is when you have a constitutional amendment like that, it really causes the courts to say, well, we've got to pay attention here, because this isn't just some regulation. This isn't just some proposal. This isn't some prior case precedent from another state. This is our Constitution, and we have sworn as judges to uphold our Constitution. And so it really does have an important role in moving these cases forward. And I understand in the election later this year, as well as in future elections, states are going to be attempting to pass green amendments. I don't know the list now of which states, but I'm sure you can look it up online. But where I'm going with this is getting involved in those efforts are would be incredibly important, because the more states that have green amendments, the more states that enshrine as rights things like a clean and healthy environment, so that the state itself will not damage citizens. It's crucial. So, let me explain. There's no fossil fuel project out there realistically, that doesn't need state approval in some way, shape, or form to operate a refinery. Everything. The state is involved as well as the federal government, local agencies, and the like. Where I'm going is, it's if you want to shut down the fossil fuel industry, the place to go is the getting the Constitution to say, state constitution to say, we need a clean and healthful environment, because there's no question, based on the evidence, that fossil fuel emissions, the various matters that are put into our atmosphere, or our water and the like, they're incredibly harmful. And so if you can shut these projects down by not getting them approved, that's, in my mind, is why we go into court. We want to make sure that the projects don't get approved in the first place, that the fossil fuels don't leave the ground. And as that's why constitutional amendments, legislative provisions, they're crucial to our cases, because otherwise these organizations, like I showed with the Rosebud mine in Montana, the states try to pass these "you can't consider fossil fuel emissions" provisions, and the state agencies are saying, hey, our hands are tied, there's nothing we can do about it. So I strongly support doing these, but doing these in a way that are effective to allow cases to move forward, to prevent the fossil fuel interests from moving forward in their projects.
The next question, and I think maybe our final question today, and I apologize for those I didn't get to. This follows nicely upon this last response. Thomas Liu writes that he was a White House energy staffer when the Juliana lawsuit was filed in 2015. Wow. He was not involved in the lawsuit and do not have a legal background, but does recall there was a lot of discussion and a lot of consternation as to why you picked the federal government to sue when we were working hard to address climate change, and we were limited by industry and interests and pushback from Republican members of Congress. Why do you pick the federal government rather than industry as your target for that lawsuit? What about the timing during the Obama administration? In retrospect, I'll note that I did not wind up taking staff time, that it did wind up taking staff time that could have been spent making progress on climate.
Okay, and again, I just want to say that if you have a court-ordered settlement, if you have a court-ordered judgment, a new president can't come in and upend that. And what we've seen post the Obama administration, post the Biden administration, is whatever was done by way of executive orders the day of the inauguration is gone. But what's going to happen in Hawaii, for example, what's going to happen in Montana, for example, they've got a Republican governor in Montana, and he's got a decision from the Montana Supreme Court that ties his hands on what he can do to promote fossil fuels in his state. In Hawaii, the Hawaii Department of Transportation, no matter how fossil fuel oriented they were before this settlement, their hands are now tied. They have to now focus on renewables. They have to promote EVs. They have to come out with alternative energy sources. We understand that the Juliana case was trying to get the third branch of government involved to support the Obama administration's efforts to make it enshrined as a court judgment. But the Obama administration was fighting us the whole time. We don't need a court-ordered judgment here, because what we're doing is going to last forever. It's going to preserve the climate. Our federal government will not be doing bad things in the future. Guess what? How did that work out? That's all I want to say, because I really think that that the current administration has shown they will not take those policies and preserve them. They will take them and tear them up as quickly as they possibly can, and that's what they've done. And they've swung the pendulum away from the endangerment finding. They've swung the pendulum as far away as possible to fossil fuels. And we need judgments, we need settlement agreements that could have been entered into, but were not. And unfortunately, we're now seeing the consequences.
We wish you luck, Godspeed tomorrow in Louisiana with your court hearing. We thank you immensely for joining us today, Phil, and for all the work you're doing on behalf of our Constitution, our climate, and all of our children and our future. Thank you so
Dina.
much.
Thank you all for attending. And again, please reach out if possible.
Thank you so much for joining us. And we look forward to our next forum with the Stanford in Sustainability Climate Action Forum.